Good morning, Mr. Towner.
Good morning, sir.
Sir, you're charged with illegal dumping. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 6 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. You understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. Is this what you want to do?
Yes, sir.
Okay, sir. How do you plead to the offense?
Yes, sir.
I'm going to find you guilty, sentence you to it. Good luck.
Thank you, Judge. Thank you.
Good morning, Mr. Torres. Good morning. Sir, you're charged with the offense of driving while intoxicated, first offense.
This is where the real tension begins. The judge isn't just listing conditions, he's laying down the rules of survival. Every line here is a legal warning dressed as advice. One slip, and Mr. Torres could lose a whole year of his freedom. Quick question, if you were in his shoes, would you take this deal or risk a trial?
You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 1 year in jail to be probated for 12 months. Is this a true first?
Yes, sir, Your Honor.
As part of the agreement, you will do a DWI education class, a victim impact panel, no breath test refusal, meaning if you're pulled over in a car, an officer asks you to submit a breath test, you must do it. If you fail to do it while you're on this probation, you're in violation of this agreement. Substance abuse treatment, no drugs, no alcohol, guardian interlock, 15 hours of community service, and a $100 one-time donation to Houston Food Bank. How old are you?
23.
Okay. Did you graduate from high school?
Yes, sir.
Okay, fantastic. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, it's over. Do you understand?
Yes, sir.
He's here on a bond violation, correct?
Yes, sir. He was supposed to have come to court yesterday, and he didn't come, Judge.
All right. Because of a bond violation, right?
I don't know about the bond violation, Judge. I think he just missed
Thought he
court.
had a bond violation. Let me see. He failed to appear in his drug test. I'd like to send him now for a drug test. Is it possible?
After we take the plea out of jail, send him for a drug test, otherwise we'll have to wait on police.
If I find that you're using while you're on this probation, I will put you in a rehab facility. If you are unable to stop, then it's really not going to go well for you. And I'm telling you, if you end up going to a treatment facility, you will be there for a minimum of 6 months, if not longer, depending on how well you respond to treatment.
Here's where the tone turns from formal to fierce. The judge's words, "We'll do it my way," carry real weight. This isn't anger, it's accountability. Judges don't just hand out punishment, they draw a line between correction and consequence. Do you think a tough warning like this can actually change behavior, or does it push defendants deeper?
Do you hear me?
Yes, sir.
Hear me loud. Hear me clear. Because after today, there's no more chances, Mr. Torres. If you fail to go to a drug test, if you fail to test, if you test positive, you will go into a treatment facility. Do you understand?
Yes, sir.
I am giving you the opportunity now to stop on your own. If you are unable to do it, we will do it my way, and you're not going to like it. The worst possible thing you can do is fail to show up for a meeting with your probation officer. If you ever have a problem, you can come here, we can talk about it, we can work it out. But if you pick up a new case, if you continue to test positive, it's really not going to go well for you.
Yes, sir.
Now, is it true or untrue that you had a .15 or above on this case? breath test?
I'm not sure what it was.
It's true, Judge. I told him he had a .15.
Okay, so true, the enhancement.
151 and
So he also has an accompanying felony with this. Is that going to be dismissed as a result of this? Do you know?
I did not know he had a felony, Judge.
Oh, I'm sorry, no, it was dismissed already earlier. All right, how do you plead to the offense, guilty or not guilty?
Guilty.
I'm gonna find you guilty. I will follow the agreement. Do you work now?
Yes, sir.
Okay, so you must maintain full-time employment while he's on probation as well. All right, Mr. Torres, good luck. Well, I'm not asking much. All I want are my streets to be safe. If you endanger my streets, I have only one place for you.
Yes,
If
sir.
you violate this agreement, I will issue a warrant for your arrest. You're facing 1 year in jail. If you fail to do your stuff on time, you test positive. Do you understand?
Yes, sir.
Okay, good luck. We'll have you see the clerk.
Thank you, Your Honor.
James.
Hey,
What's this?
what are you looking at there?
They just gave me these things here.
For objection?
No. For findings of fact, I guess. I don't know.
Oh, they never do that. No one ever follows that rule.
Here's one on mandamus and writs of prohibition. So a prohibition is to prevent the commission of a future act versus a mandamus is to nullify an act already performed.
Yeah, that's never gonna. Are we doing writ of mandamus on our case?
It would be a prohibition.
See?
But you gotta file it in the Court of Criminal Appeals.
Right, because everybody always wants to do that one. That's never, it's like a rare unicorn.
You ready?
At this point, the courtroom vibe shifts again from tension to quiet strategy. The lawyers are diving into case law, but what's really happening is a battle of logic versus evidence. Each word could shape the next verdict. It's the calm after the storm, or maybe just the setup for another twist. Would you side with the defense here or the state?
Yeah. I was just,
Did you email me? I didn't see.
no. I still think, based on the cases that we submitted, the state submitted a good case.
I did have another case, Your Honor, and I
The
have
reason
not
I-
had a chance to print it out yet, but I can do it for you right now if you'd like to look at
Did
it.
you email it to me?
I can also do that.
It's a waste of safe paper. Take it.
Okay, and yes, it's a similar case than the one that I sent you yesterday along the same case law. So this one also occurred on Southwest Freeway, this is where this occurred, so exact same location, same situation.
The reason I like that case,
Hold on, let it finish.
I thought she was done, sorry.
Sure.
That's about it, Your Honor. Let me find it.
Exact same thing
On the same freeway, yes, Your Honor.
on the same freeway, but not in I guess in a tow truck.
Okay, let me see.
I think she's seen near the car, not in a separate car, separate vehicle. Correct. So that's the distinction.
It is, Your Honor, and I would argue that that's not a worthwhile distinction. If you watch the body cam in this case, the defendant's vehicle is parked directly behind the tow truck. Whether they were seen outside the tow truck or she's inside the tow truck, it really does not make a difference.
She's never seen in the alleged vehicle. But the main thing I was gonna point out, if you read all the,
But that's a fact, but I don't think that's just dispositive of the whole thing, right?
okay, I know, but so that's what I'm getting at. If you read that case, they stress like, hey, we don't want to convict people on their statement alone. That's why we have this rule from 1957.
The distinction is a conviction versus probable cause. This is just a mere probable cause. Here,
No,
is there enough to go forward? Perhaps. Is there enough to convict?
no.
Right.
They have to have, this is a corpus delicti issue. They have to have corpus delicti to proceed with probable cause. So it's probable cause. I guess what I'm saying is they're stressing that there should be other corroboration other than mere statement of defendant. There's a rule called mere presence alone. You know that rule.
Yeah.
She's
but
just
there
present.
but there is corroborating evidence.
Okay. Well, that's where we disagree, so.
How else would she be there? It's the middle of the night.
Your Honor, it's just to be clear,
it's
it's
not.
not the middle of the night. It's around 7:30 in the morning. The part of the freeway that they're on is a part of the freeway where two highways are converging, and they're in the middle center shoulder, if that makes sense.
Wait. Okay.
So our argument here is that there's no way for the defendant to be able, or anybody else, to be able to leave, because there's 3 lanes of traffic in morning rush hour on the left and 3 lanes of traffic in morning rush hour on the right. And to further that, Your Honor, the defendant also does, and yes, I know it's a statement by the defendant, she does say that nobody else was in the vehicle with her, and that she was alone.
I mean, I think there's enough to go forward.
I was just gonna say one more thing.
Okay.
This whole thing about, oh, it's easier to find someone on the side of the highway. Again, I don't know who believes that or why that's
I
some
mean,
type of fact.
I'm looking at everything, the totality of everything, right? Now, this is just probable cause, right?
Yeah, I've already tried the whole case, so why, I'm feeling good about it, right?
Yeah,
Okay, so I'll get her a rescheduled date.
of course.
Thank you.